was under ROPA 2009 was issued on 6th February 2016 with effect from 1st April 2016. 26th February 2016. However, the amount was not disbursed due to pendency of the criminal proceedings. Subsequently, the amount has been disbursed in favor of the petitioner.
On 6th, paragraph 12.
On 6th, give the date.
6 July 2023.
6 July 2023. The petitioner was also given pensionary benefits in terms of ROPA 2019 on 15 July 2025. The petitioner seeks for arrear from the date following the date of discharge, that is 23rd, 28th September 2022 till 15th of July 2025, together with interest.
Okay, may I submit? Today I am praying only the interest on area. Because area has been given. Yes. The interest has not been given from those dates.
The petitioner seeks for interest on arrears of ROPA 2019 from the date following the date of discharge till the date of when till 15 July 2025. The report filed by, you are filing this report?
Yes.
Report filed by the District Inspector of Schools within bracket Primary Education South 24 Parganas dated 29 July 2025 is taken on record. Learned advocate for you are representing?
District Primary School Council.
Learned advocate representing District Primary School South 24 Parganas and as well as state respondents submits that the petitioner is entitled to the said benefit. Accordingly, in view of such submissions, respondent number 6, respondent number 6, head teacher, Heliagachi FP School, is directed to calculate the interest from under ROPA on the arrear under ROPA 2019 from the date following the date of discharge till 15 July 2025 and forward the same to the
District Inspector of School.
District Inspector of Schools.
Respondent number 3.
Who? Now, District Inspector will send it to the Treasury Office.
Treasury Office.
Yes. Respondent number 8.
And after proper verification and authentication.
And after proper, the District Inspector of Schools PE South 24 Parganas, after proper verification, will forward the same to the director is not required in this case.
No.
Treasury Officer, Diamond Harbour, for disbursement of the same in favor of the petitioner. The aforesaid exercise shall be completed within a period of 6 weeks from date of communication of this order.
My lord, only one line is required for the benefit of the petitioner. If any objection raised by any authority, that should be communicated to the petitioner.
The objection, if any, raised by the concerned authority shall be communicated to the petitioner forthwith.
My lord, don't take me amiss, my lord. It is a benefit of
That's
Yeah,
only one
Thank
thing of the rate of interest.
at the rate of 8% per annum.
grateful.
8 again.
Please first.
Item 6. Well, I am for the petition.
I'm for the DPSC. How did Mr. Vishwas?
Here the petitioner is claiming for the compassion claim. My lord, I will place the case. My lord, petitioner lost her husband in the year 2014. My lord, kindly come to page 29.
Husband is the employee.
Yes, my lord. Husband was the teacher in the school. On 25th of March 2014, her husband died. My lord, then petitioner made an application on 24th June 2014, which is in page 33. Kindly note, husband was a teacher. Petitioner made an application prayer for appointment as teacher of such and such. My lord, this application reached to them. The proof is there in page 34, that is peon book, and other documents are there. Now, Lordship, kindly take the order passed by the DPSC, which is in page 60. They were considering it, but in response to the application dated 25/8/2023, sent through register post claiming appointment under die in harness category against in-service death of Pintu Dhara, assistant teacher of Notipur, Sita Mata Primary School under Domjur Circle. Srimati Tinamoni Dhara attended the hearing, which was scheduled vide memo number 936 dated 5/6/2024, but she failed to submit all the related papers and documents as required under item number 1 to 13 listed in memo number 936 dated 5/6/2024 on the date of hearing. After going through the such and such, these are observed that an application was submitted by Srimati Tinamoni Dhara, widow of late Pintu Dhara, for appointment under compassionate ground earlier on 15/11/2016 and was submitted to the office of the DPSC Howrah on 3/1/2017. Pintu Dhara, assistant teacher of Notipur Sitamata Primary School, died on 25/3/2014. As per government order, the claim for appointment under die in harness category should be submitted positively within 2 years from the date of the teacher. As per records, the application was submitted by the applicant firstly on 15/11/2016, which is wrong, and secondly on 25/8/2023. Prayer for appointment under compassionate ground was submitted after 2 years from the date of death of Pintu Dhara, assistant teacher of such and such school, which is beyond the rules. The district primary school council is not in a position to consider. So it was never considered by them. They took the point of that 2 years, it was not submitted within 2 years. Hence, we are not going to consider. Can it be the scheme of compassionate appointment implemented in such way? Lordship, when the Supreme Court directs, Bhavani Prasad Chaudhary.
When was the application made at first?
That was the page 33, my lord. Kindly come to 24/6/2014.
So what happened to that application?
They have not said, they have not considered. Cunningly, they said, no, we have not submitted it. Because, Lordship, the only thing, kindly come to page 35 also. This is family composition certificate, which was also obtained. Thereafter, every other documents were also submitted.
Peon book. No, first this application is sent to which authority? At the first instance?
My lord, here it is before the chairman DPSC, my lord.
Chairman DPSC is the appropriate authority to accept those documents, those applications? To which is the date he has accepted?
My lord, the date is this was 24/6/2014,
14.
and this was sent through the sub-inspector of the school, Lomju Circle. The stamp is featured on the letter.
Yes.
Now, Lordship, the Supreme Court says repeatedly in 2011, Lordship, is that while considering the claim of employment on compassionate ground, the following factors have to be borne in mind.
Paragraph.
Lordship, these are para 20.
Yes.
Reference yes, 2011 4 SCC 09. Thus, while considering the claim for employment on compassionate ground, the following factors have to be borne in mind. 1. Roman 1. Compassionate employment cannot be made in absence of any rules or regulations issued by the government or public authority. The request is to be considered strictly in accordance with the governing scheme, and no discretion as such is left with any authority to make compassionate appointment derogates of the scheme. An application for compassionate employment must be preferred without undue delay and has to be considered within a reasonable period of time. An appointment on compassionate ground is to meet the sudden crisis occurring in the family on account of the death of the medical invalidation of the breadwinner while in service. Therefore, compassionate employment cannot be granted as a matter of course by way of largesse, irrespective of the financial condition of the deceased, incapacitated employee's family at the time of his death or incapacity, as the case may be. Compassionate employment is permissible only to one of the dependents of the deceased incapacitated employees, parents, spouse, son, daughter, such and such. Now, tasted on the touchstone of these broad guidelines governing appointment on compassionate ground, we are of the opinion the appellant has made out a case of such appointment. It is manifest that in terms of the circular dated such and such, only those employees who have been totally incapacitated from the performing any service were entitled to seek compassionate appointment. Now, Lordship, kindly come to their scheme. Kindly come to page 47. In exercise the power conferred by subsection 1 and clause K of subsection 2 of section 106 read with clause K of subsection 1 of section 60 of the West Bengal Primary Education Act 1973, the rules are notified. Now, Lordship, kindly come. The rules kindly come to page 51, rule 14, appointment on compassionate ground. The council may, page 51, bottom.
Yes.
The council may appoint primary teachers with the approval of the director of the school education, West Bengal, or his authorized officer, or compassionate ground in following cases where the opinion of the council, the cases deserve compassionate consideration. Other essentials to the surviving members of the deceased teacher's family, following members of deceased family teacher's family: widowed wife, widower son, unmarried daughter, divorcee, dependent daughter divorced before the death of the teacher, possessing required educational qualification as laid down in clause A to C of subrule 1 of the rule 6, and possessing unemployed and not below the age of 18, not above 45 years, found eligible to make such and such. Now, when the primary teachers applies for being declared permanently incapacitated on the medical ground, such and such, then Lordship, this comes. So only thing is that this were the requirement. This has to be considered on the basis of Rule 14. My Lord, that was not considered, never considered by them. Now, Lordship, kindly come to page 56. This is page 55 and 56. They accept about these two documents.
56.
Page 55 and 56. While considering, they accept this document. I herewith inform you that my husband, late Pintu Dhara, assistant teacher, Natipur Primary School under Domju Circle, expired on 25/3/2014. His last working date of the school was that he was the only earning member of the family. So I shall be obliged, kindly grant me the service to help in my family to take such and such. Then I provided entire details as per their documents and enclosure, death certificate, qualification certificates, income, residential certificate, ration card, family composition statement.
No,
Next page,
where is the rule of 2 years? Your consideration they have not considered because it is belated application. They say.
they say.
Where is that rule that 2 years we have to
My
file?
lord, that 2 years rule, they are saying,
There is no such specific rule that two
I
years.
have not found.
No.
So far that particular thing is concerned.
Okay.
And however, my contention will be, if that is also the rule, once the application is made and it is on record that I've given it, they must have considered it and decided on the basis of this application and decided on merit. They have not done so. In order to just overcome that, they have now taken this aid of this 2 years belated filing. Whether my contention will be, my lord, whether that will substantially affect my case.
But then, if the rule says that within such and such period one has to file an application, and it is not filed.
My lord, that
Suppose
will
in a
be,
case in a case where it is filed after 5 years.
that
Now,
will
what
be,
consideration
but
remains?
delay will be
Because
considered, but lordship, the question that Supreme Court said, the broad spectrum on the basis of which this should be considered, that will not probably substantially not affected because of this.
But then the first clause of that particular conclusion says that the scheme has to be adhered to. If the scheme says that you are debarred from considering any application after the year 2 years, then how can they
Lord,
consider
let them produce this scheme, Lord.
that
where
2 years
it
is
there.
a barrier to you? You say that in June 2014 you have filed. Within
It is
3
there,
months,
it is
3
there.
months, it is there. So they have noted that 15th November is the first application. But you
I
say that
consider
June
that
14
the
is
first
first.
application is in
June. Yes, Mr. Biswas.
My lord, your lordship has, my lord, my learned friend has shown the impugned order passed by the chairman, DPSC. My lord, rule says, my lord, any compassionate appointment, my lord, has to be applied by 2 years from the date of the, my lord, my learned friend has, my lord, if in your lordship, my lord, my learned friend has placed the, my lord, rule page 52, your lordship, my lord, rule 14.
Yes.
Starts from page 51. The appointment on compassionate ground. The council may appoint primary teachers with the approval of the Director of School Education, West Bengal, or is authorized officer on compassionate ground in the following cases where the opinion of the council cases deserve compassionate consideration. I'm just skipping over. Then, my lord, possessing required educational qualification as laid down in clause A and C of sub-rule 1, rule 6. Rule 6, and employed and not below 18 years of age and not above 45 years of age and found eligible to teach may make within 2 years. Your lordship, kindly, my lord, mark. Within 2 years from the date of such death, a prayer in writing, kindly mark, my lord, a prayer in writing to the council for appointment as primary teacher on compassionate ground, provided that only one member of deceased primary teacher's family may be appointed on compassionate ground. My lord, my learned friend has relied upon these rules. My lord, say, my lord, this rule is not applicable. My lord, because this is a 2001 rule. My lord, this rule was amended. The applicable rule, your lordship will find, my lord, from the, my lord, this spiral binding. My lord, this is page 94, your lordship will find. This is a relevant rule. This 2001 rule was amended in 2012. After, my lord, RT Act, my lord, came, my lord, this rule was amended. your lordship will find page 94. Because why I tell your lordship? Because Malad, the rule 6 was amended. Initially, Malad 2001 rule, the Madhyamik was the qualification. Madhyamik was the only qualification. Thereafter, after Malad, the RT Act came into force, Malad, your lordship knows, Malad, TET is compulsory, mandatory, and Malad, the educational qualification, higher secondary with 50% marks or graduation. Because of this, Malad, rule was amended. Your lordship will also find here the compassionate appointment at page, your lordship will find, my lord.
That is on merit, my lord. Let them enter into that.
I'm
have
just
never
coming.
entered.
I'm just coming, my lord. Rule 14 was amended.
11.
At the last page, page 101. Page 101. Your lordship will find. Got your lordship? Page 101. Your lordship, the rule was amended into 14 sub-rule 1 for the word disease teacher family. Substitute the following word figure, letters and brackets. Of the disease teacher family who is possessing required educational qualifications add laid down in rule 6, not below 18 years of age, 45 years age, and as obtained 55% marks in the teacher ability shall be considered for compulsory appointment. Because, my lord, here your lordship will find, my lord, rule, just your lordship compare with this, my lord, page 51, page 52, your lordship. That portion, that the educational qualification, because at that point of time, rule 6, 2001 rules was Madhyamik. Because of this change, Malad, this was incorporated, amended. So therefore, Malad, the 50% marks in the higher secondary has obtained at least 55% marks in the teacher ability test. Malad, because Malad, the TET Malad qualifying marks is 60%. Because of the compulsory appointment, 5% was given relaxation. That is why 55% marks. Therefore, one for asking for compulsory appointment has to clear TET or qualify the TET. But this is a eligibility criteria. Then your lordship, admittedly, your lordship will find the first application before the appropriate authority.
Just wait for a minute. In rule 14.1. In 14.1, where is these words of the deceased teacher's family appearing in 14.1?
Page 51, your lordship will find page 50, just page 51 bottom, then 52. The other essential serving member disease teacher's family, page 52, top.
Yes, deceased teacher's family.
The following members of the disease teacher's family is widow, wife or widower or son, unmarried daughter or divorced, possessing required educational qualification as laid down in clause A, C, sub-rule 1 of rule 6.
Yes.
Therefore, this means the 2001 rules, sub-rule 6. Sub-rule 1, rule 6. If your lordship kindly, my lord, come to page
48 and niche chole jao. Qualification.
48. Bottom. 48 bottom.
Yes.
My lord, qualification. No person shall be appointed by the council as teacher unless he has completed the age of 18 years. From the January in the which requires sending names of the candidate made employment exchange concerned, the possessing minimum educational qualification and mentioned in rule 2. The school final Madhyamik pass under West Bengal secondary education equivalent within training or erstwhile higher secondary 11 was But this is the the qualification. The Madhyamik was the qualification. Because of the RT Act, the entire the
Okay.
picture changed, and therefore this rule was incorporated. So therefore, two things, for compassionate appointment. Statute says, one, you have to either you have to be the 55% in higher secondary and TET qualify. So this was the two criteria. Educational
So
qualification.
far as the time limit is
2
concerned,
years,
2
2
years
years.
is
It's
there.
from consistently 2 years. This is.
Okay.
And the another thing is, the compassionate appointment, one has to apply before the appropriate authority, means the council. The statute says. He has not made any application before the council. For the sake of argument, if your lordship assume that he has applied, where is the copy of the application? I am asking myself. The read petition is on oath, or it is in evidence. Where is the annexure? He has to annex showing that he has applied to the council, the chairman of the council, within 2 years from the death of his husband.
Page 33.
Page 33, your lordship kindly see, page 33 is not the
Chairman of the district primary school council.
That is a
Common
forwarding. That is a
Wait,
forwarding,
wait.
but my lord.
No, I'm just coming. Page 33.
No, in the rule where it is stated that this application is to be made before the council.
Page 33 is the who is doing this. This is sub-inspector of school is forwarding this to the council.
Yes.
If your lordship, for the sake of argument, assume this is a authentic document, this is to the SI, sub-inspector of school, is forwarding it to the council. That is also 24th July 2014. That is also after 2 years.
What? After 2 years?
No.
Yes,
He
your
has
lordship.
died in the month of March 14.
March 14. Yes, your lordship, March 14. This is
within
before
2
the.
years.
I'm sorry. Yes, my lord. Absolutely. This is a this is by the sub-inspector of school. That was in the impugned order. That was not accepted by the authority.
But then, in that event,
Malad.
the authority ought to have issued a letter to the petitioner asking her that you file it before the chairman of the council, or the sub-inspector could have intimated. Now, if a person having no knowledge as to which is the authority where the application is to be filed.
One, your lordship, one knows the compassionate, I am entitled to get a compassionate appointment. So therefore he knows the rules. Because of the rules, he knows this is a compassionate appointment. I am entitled to get the appointment, died of my husband. That is why he has made an application.
No, you might have a format for application that is not known to the petitioner.
My your lordship,
Now, if
kindly
a
see, he has made
application
an
is
application. He made an application in 2017. He has annexed it. Therefore, it is knowledge of the petitioner that he knew this. The application has to be made before the
Page
council.
55.
Page 55, your lordship, kindly come. 2017, he has made an application before the council to the chairman, district primary school council. Appointment of the ward deceased assistant teacher. Therefore, your lordship, after this, we cannot say he is not knowing the law. And
I'm asking this question to myself whether the impugned order stands. The impugned order is a complete falsification by the person. False statement. You should come to the dock.
Comrade, then, your lordship, if your lordship see, the impugned order, first impugned order, was not accepted on the ground that he has to make an application within 2 years, as per the statute. Your lordship kindly consider this order, this judgment. This judgment was of our High Court, the larger bench judgment, 3 judges bench judgment. Purely, sir. After this judgment, my lord, your lordship kindly consider. পড়া যায় না একটা আমার কি ছিল পিয়ালিশা এখানে নেই The pat on the point, my lord, 2 years.
Yes.
And my lord, the ultimately, my lord, the special bench says, my lord, that the statute, when the statute says 2 years, 2 years is the mandatory.
Yes.
But then what happened to the June application?
My lord,
What happened to the June application? She made an
my lord, I'm
application for
asking myself, where is the application? There is no application as of, my lord, as of today.
but
My lord, he has to annex.
33 and 34,
My lord,
33 and 34, it says that it has been submitted before the authority.
My lord, just your lordship kindly consider this 33, page 33. This is the, my lord, the forwarding letter of the SI, my lord, page 33, my lord, to the chairman, Howrah District Primary School Council, by the,
That
my lord,
shows
sub
that they
inspector
knew
of
it.
school. My lord, that, my lord, if your lordship, my lord, as you, my lord, this is not before the, my lord, appropriate authority. My lord, 33 is by the sub inspector of school. My lord, the petitioner has to make an application before the appropriate authority. But this is not there.
The sub-inspector of school did not inform the petitioner that this is not,
Malad,
you should file an
for
application
the
for.
sake of Malad, this is not also the Malad obligation to the sub inspector of school to Malad inform the petitioner that this is not the authority. You have to apply before the Malad. The petitioner knows the law. That is why he came to the government for appointment of compassionate ground. My ignoring the law or Malad not knowledge of the law, Malad doesn't Malad create any right or Malad the health.
Why they have not rejected it in that time only?
My lord, the first hurdle is 2 years. Then, my lord, the another hurdle, my lord, the rule says, my lord, that 55% marks, 50% marks in the higher secondary and qualifying TET. My lord, let my learned friend so he has qualified the TET. My lord, ultimately, he is paying for appointment on the compassionate ground.
But that
As per
cannot
the
be
rules.
raised
Arey,
against
please,
him.
সময় পাই।
My lord.
As per the rules, my lord, ultimately, my lord, he has to satisfy your lordship that he has, my lord, passed qualified TET. He has not annexed it, the proper qualification in the writ petition. He has to show before your lordship that these are my qualification for appointment of the compassionate ground. My lord, he has not annexed in the writ petition that he has passed the TET or my lord 50% marks in the higher secondary, and my lord now is a training. The rule was amended.
So you have passed it.
I have to take instruction on that.
My last occasion also, your lordship, when your lordship heard the matter, this was foreign from exactly your lordship.
That will not fall within the scope of this
But
writ
it's
petition.
supposed to come with the
Because
instruction
that
today.
will say, that will definitely render this particular impugned order set aside. If I say that, if I enter into that zone now. Lordship, the thing is that they have never considered it. If their decision was that you did not possess the qualification, then my learned friend's argument would have been accepted by the court. At this juncture, since they have not considered it, just citing the rule related to that 2 years limitation, therefore, Lordship, this other corollary will not be considered at this stage, may not be required to be considered. They should be relegated back to my learned friend's client, and they should give us a hearing, and petitioner would be given a chance to produce.
But why the application will be taken into consideration, which is belated one?
It is not belated, my lord. I have shown. Lordship, now take this example.
My lord, the another thing, if your lordship accept this page 33, my lord, if your lordship, my lord, for the sake of argument, if your lordship accept this, my lord, ask the SI, sub inspector of school, before your lordship, and with the application that is made before the sub inspector of school.
Let
There must be a, my lord, the hard copy. On the basis of that, he forwarded it.
Filed by the SI.
I do not know whether this is a manufactured document or not.
Let the affidavit be filed by
because this was not considered by
Lordship. Let the
we cannot both. We cannot say. Let him argue, my lord.
Lordship, if this allegation is leveled today, I invite an affidavit to be filed to that effect, and let everything be solved. Let the SI come and file an affidavit to that.
But what has been done is it,
and let an investigation take place.
what has been done is that it has been not made in a proper format.
No, FIR follow.
It has not been made in a proper format. The district primary school, the application had to be made to the district primary school council, which has not been made, which was made much later in 2017, which shows that they all along knew that the application has to be made to the district primary school council, and which has been clearly enshrined in the rules, that you have to make the application to the district primary school council and not any other authority.
No,
So
my query is that the responsibility also does not lie upon the authority where wrongfully, unknowingly an application for compassionate appointment has been made and the authority did not inform the petitioner that I am not the appropriate authority. You file an application before the council.
But this is
But
not
it was
the
not known.
of
This
the
is
authority to
known.
inform.
This is
There
known
is
to
no
everyone.
in the rules, there is no obligation on the part of the authority to intimate each and everybody that look, this is not the proper application, this is not the proper authority you do to this particular authority. This is not the obligation of the authority to intimate.
This is the appointing authority is the district primary school council, so they all along knew it.
He should have been annexed the
File a report whether such application has been filed. We will decide this. Mr. Sobhusaji Chatterjee, learned advocate for the petitioner, submits that the petitioner's application for appointment on compassionate ground was rejected by the District Primary School Council Chairman, District Primary School Council, Howrah, on the ground that the application has been made after 2 years at a belated stage. In the impugned order video order dated 20th June 2024. In the said order, 2 applications have been indicated dated 15th November 2016 and secondly on 25th August 2023. Stop. However, it failed to take into consideration the application which was made on 24th June 2014 after 3 months of the death of the deceased employee. Relying on the decision of Honorable Supreme Court passed in Bhavani Prasad Sonkar versus Union of India and others, reported in 2011, Volume 4, SCC 209, he submits that the application for compassionate employment must be considered within a reasonable time frame to meet the sudden crisis occurring in the family on account of death of the deceased employee. The application of the petitioner for appointment on compassionate ground has not been considered on merit. On the contrary, Mr. Ratul Viswas, learned advocate appearing for the DPSC Howrah, District DPSC Howrah, submits that the rule of 2001 has been amended in the year 2012. The petitioner has not produced any document showing her TET qualification, teacher's eligibility test within bracket. Within bracket, teacher's eligibility test within bracket, in short TET. Moreover, the scheme of the appointment on compassionate ground clearly lays down that the application has to be made within 2 years. In the present case, that has not been made within such period. There cannot be any extension of the time period for seeking employment on compassionate ground. To buttress his contention, he relies on the decision of this larger bench of this court in. Please find it out. It has been like such and such.
2023 বোধহয় পিয়ালি
He also indicates that
Taxation, page 18. 2013
original
page 18.
original copy of the application which has been sent to the sub inspector of schools has also not been annexed to the writ petition. এটা ওই আগের ডিসিশনটা হচ্ছে পিয়ালি সাহা ভার্সেস স্টেট অফ ওয়েস্ট বেঙ্গল reported in 2013 volume 1 CHN bracket cal page 18. Can we give a copy of this?
I'll just. And a
Acha.
copy.
Bolo. Mr. Swans, you are for the state.
State.
Mr. Swansol, an advocate for the state, submits that the petitioner was fully aware of the rules for getting appointment on compassionate ground. The application for compassionate appointment ought to have been made before the council, which has not been made in the present case. And subsequently, after expiry of 2 years, such an application has been made. He seeks to file report in respect of the document annexure P3 at page 33 of the application. Accordingly, state is directed to file a report within a period of 1 week.
2 weeks, my lord.
2 weeks, exception in the form of affidavit you file. Exception, if any, 1 week. List this matter after 3 weeks.
Review.
কপি দিচ্ছেন
Item 7.
I have the statement.
During the petition is not relating to the grant of family pensions to the unmarried daughter.
Exception,
But exceptions report has already been filed.
fine.
The report has already been filed and also will accept the report also. But here is the case. A concerned teacher was appointed as a health teacher. Having the 1988, thereafter been extended in November 1989. Then he died on 15th July 1991. 31st May 1991 extended, 15th July 1991 they died. Thereafter, the Director of Pension issued a letter returned to the authority to submit again because the pension payment order is to be issued of the teacher who is under the CPM, Contributions Provident Fund. Now, ultimately, the mother of the petitioner said applied for granting family pension. Now, on 11th 2022, then pension payment order was issued on 12th September 2022. Only released the CPF amount. That is the only gratuity amount. Because the Contributions Provident Fund has not been options given by the teacher who has already been extended period in 1989. Now, on 3rd February 2005, the mother of the petitioner, Durgesh Nandini, also died.
Sure.
Now, after that, the petitioner, who is unmarried daughter, applied for grant of family pension on 17th December 2024. Ultimately, on 17th January 2025, the concerned DI has been dismissed or rejected of the claim of the petitioner regarding the grant of family pension.
Where is that order?
But there is on 17th January 2025. At page 9 and except page 41. on the office of the application under memo number with reference to the subject cited above, this is to inform you that your father, great Bireshwar Chandra Goswami, is a teacher on Madhusudan Chowk LP School under Mudra Circle, died on 31st May 1991. In extension period of service, and he was under contributory from gratuity scheme as per DPO. Accordingly, DPO has been issued by memo number such and such, bearing DPO number such and such, as per DPO number 136 CDN B. In 1955, he was not entitled to get pension or family pensions, and there is no provisions to exercise of the decision. If the office is not in a position to consider not applicable. So ultimately, this petition has been filed and challenging of that order, relying on the judgment of the Honorable Division Bench, passed on by Lord, the larger bench is also by the 20th June 2023 and also the 24th August 2023. Your Lordship kindly state exceptions of the report in which I have already annexed the judgment of the Honorable Division Bench. In Promila Behra. Promila Behra, page 9.
Exception.
Exception. I have already annexed in this judgment. Judgment was delivered on 11th December 2023. It has also been considered on the larger bench judgment that your Lordship may kindly relevant page, paragraph.
Well,
Paragraph 10, page 19. Person who has already retired at the age of 60 years, hoping that he shall get pensions and gratuity, can he now be said that he cannot get the benefit because he did not exercise the option.
which paragraph? Which judgment you are reading?
Last
Page 9, para 9.
9.
Para
Last
9,
post,
yeah,
last paragraph.
Page 19.
It's not click here.
Yes.
That a person who has already retired at the age of 60 years, hoping that he shall get pension and gratuity, can he now be said that he cannot get the pension benefit because he did not exercise the option? The state took the benefit of the early retirement of the teachers and now is seeking to deny the benefit of pension and gratuity. The husband of the petitioner died in 2005, long before the judgment of the larger bench. Therefore, the questions of denying the pension and gratuity to the widow does not arise. Ultimately, paragraph 10, in fact, the Director of Pension Provident Fund and Group Insurance Government of West Bengal has accepted the said judgment in deciding a representation of a widow, namely Putul Mondol, in WP number 614W 2016, in a written order dated 19th August 2021. The defense of the Director of the said matter is introduced to widow. Hence, in terms of the ratio laid down in the review application bearing RPW number 68 of 2016 and in consonance with the order dated 16 July 2023, passed by the special bench of this Honorable High Court, Calcutta, in connection with APO number 94 of 2009, I am of the view that the petitioner is entitled to get family pension in terms of GO number 949, 749 ECL dated 13 June 2014. That is from the date of refund is made. Therefore, the concerned distributor schools is directed to inform the petitioners to refund the actual amount of the employer's share of contributions along with interest to the calculated by the concerned distributor schools within 2 weeks of the of this order. The liquidation is directed to refund the employer share of contribution along with interest as calculated by the concerned district within 2 weeks. After completion of all these penalties, district inspector schools concerned is directed to prepare family pension case of the petitioner and the same shall be sent to the office of the DPGP within 15 working days thereafter for issuance of the PPO in favor of the petitioner. Thus, the matter is disposed. The order is issued in compliance with the order detailed circumstances passed by the Honorable Assembly. Now, paragraph 11, my lord, we have also independently considered the matter in Mukti Pal, this in paragraph 7. It appears that before the learned single judge, the aforesaid decisions have not been placed and hence the learned single judge did not have the benefit to consider the same decisions in deciding the matter. The grounds for delay is also not relevant as an application was filed by the petitioner for family pension in the year 2006 and the state is unable to offer any explanations for not considering this application and giving benefit to the petitioner even after the special bench decision. The paragraph 12, this is a valuable right as that has accrued in favor of the petitioner of which he cannot be denied. As observed earlier, the husband of the petitioner had already agreed to reduce the age of permission and thereby had suffered financially. The widow cannot be made to suffer by reason of the long interpretation of the relevant provisions of the scheme or the judgment of the special bench. In fact, as observed earlier, the authorities concerned had already accepted in principle that the widow will not be required to exercise any fresh option had the teachers been alive when the special bench delivered the judgment, questions of exercising options become irrelevant. In this instance, there was no scope to switch over options of the teacher concerned as he was dead on the date of the judgment. Furthermore, the husband of the petitioner exercise options under Rupa 1998 and 1990 in view of thereof, the judgment is satisfied. The respondent authorities are directed, thereafter it is directed to calculate the employer share of contribution provident fund with interest and additional interest which the petitioner is required to refund for availing the benefit of pension cum gratuity scheme and intimate the same to the petitioner within a period of 8 weeks from date. The petitioner shall deposit the specific amount of the employer shares of CPF with interest and additional interest to the concerned district office dated on the date of receipt of the statement of return. The concerned district school shall send the pension paper of the petitioner to the office of the direct pension provident fund group insurance West Bengal after verifying the same and shall issue pension payment order in favor of the petitioner within 2 months thereof. In computing the interest, the appropriate authorities shall take into consideration across 3-4 of the notification dated 13 June 2014, which has prescribed the rate of interest to be paid towards refund of the employer share of contributions provident fund up to the date of exercise of option. The family pension shall be payable to respondent from the date of actual superannuation and or the date of the concerned teacher as the case may be. Let area of the pension be paid to the petitioner's respondent within a period of 3 months of issuance of the pension payment. Now the questions has been observed of this honorable division bench of my lord justice. Then the fact the relevant of this case is similar that the petitioner is a widow daughter. She is getting for paying for family pension. And
Which one?
unmarried daughter. And if you lot
Which judgment?
payment,
Which judgment?
Madam?
Which decision?
this the Promila Bag.
Promila Bera is a widow, not the. Promila Bera is a widow,
Unmarried
not the daughter, unmarried daughter. Where is it?
Widow, but widow had died. Thereafter, unmarried daughter has been applied.
Mhm.
That was rejected on 1985 schemes by the concerned decision.
Paragraph 18.
Then the judgment had been delivered prior to that, my lord. The teachers had died.
Yes.
Madam, your petitioner father not changed CPF to DP. He died 1991, and her mother was died 2005.
1991 he died.
Yes, ma'am.
Final supervision. Living after extension.
What is in the report?
Fine. Paragraph 8, my lord.
Yes. Any other thing? Any other aspect you intend to submit?
Yes, ma'am.
Yes. What is?
Well, my lord, as per report, within 3 months, 3 month time period be given to them the exercise, and actually each and every employee who elect to switch over the pension come gratuity to deposit the amount of employee share of contribution with interest at additional interest which is equal to but no scope, my lord. Your petitioner father is dead 1991. And your petitioner mother was died.
Did the mother file any application for switching over?
No, only
No, they did
applicable
not.
for grant of family benefit. Now, they have been directed to the director of school, provident fund and group insurance issued a pension payment order only to release the gratuity.
Yes, my lord.
Only the CPF amount has been released.
In favor of unmarried daughter?
No, my lord.
No,
Petitioner mother.
petitioner mother was a widow.
The mother did not approach the authority for
Yes, yes.
switching over?
Mother was also my lord approved,
Where is that?
but my lord, that is page 11th November 2022. My lord, I am showing. Yes, my lord. Page 23, my lord. 22 onwards. It is Durgesnandani Goswami, a widow mother of the petitioner. Because the order of pension payment was prior to the page 21. That the pension case in respect of late Giresh Chandra Goswami is returned herewith along with the connected papers for the reason stated below. The request that he will kindly rectify the defect point out the resubmission of the claim. One is LPC, this is the last payment certificate should be submitted formally, and second, calculation 6 should be verified by the finance officer. Now ultimately, let's see has done. Annexer page 22, 23, 24, 25, 86, and also 27.
No, where is that application that's the intends to switch over from CPF to GPF?
So there is no scope because 1991 the teacher died.
Hmm.
But after that, decision with special with judgment is 2024, 2014. So there is no scope as it appears in the report as made by the distributor school, para 8. So on the basis of that, the 2014 special bench judgment, my larger court has been submitted that he is not unable to consider the applications of the.
This is 2014. Which judgment? Oh, which is Boito?
That is the larger judgment. But there is directions within 3 months from the date of choice of options to review. But prior to that, cannot be done.
But only
To get right. Now, according to the Provisional Virus, this has been considered both the cases of the special bench judgment as well as the other judgment of the learned single passed by this court.
The large judgment decision has been passed on which date? Switching originally decided 13th, the same as real
2020. 21st April 2023. Page 43. Judgment delivered on 20th June 2020.
June.
no scope. No scope ही नहीं थी किसी को.
In which paragraph?
These judgments should not be applicable to this case because they will consider prior to Act 1st April 1981. That special bench judgment.
Which is applicable in your case?
Applicable in the division bench of what
Pramila Bera.
Yes. Only few exceptions. And it has been also considered that there is no scope for any the widow
Unmarried.
wife as well as the unmarried daughter has no scope to choice of option trade. They will consider that if any amount has to be paid along with the calculation sheet of the interest of the CPF amount to the authority, and authority will do the pension payment for grant payment. Petitioners agree to make payment to the CPF account.
Awesome. By the present writ petition,
আমার তো বলার কিছু নেই.
the petitioner seeks for setting aside of the order dated 17 January 2025 passed by District Inspector of Schools Primary Education being Annexure P9 and consider the application dated 17th December 2024 of the petitioner, Annexure P10 F res. The petitioner contains that her father, namely Bireshwar Chandra Goswami, was the head teacher at Madhusudan Chowk Pre-Primary School, Mathurapur South Circle, Post Madhusudan Chowk, District South 24 Parganas. When did he retire?
That means, died in, was retired, that internal 31st May 1991. He died.
31st May 1991.
He's
On the, like,
When did he retire and when did he die?
31st May 1991.
19 November
Extension of
88. He's
And
retired, but
died.
extension, 1 year extension.
1 year.
Yes.
So 18 November 1989,
Yes, sir.
Yes.
you know, the service of the petitioner's father was extended from 19th November 1988 to 18 November 1989. The father of the petitioner died on 31st May 1991. The mother of the petitioner, namely Durgesh Nandini Goswami, submitted the last pay certificate of the deceased employee and made a declaration before the concerned sub-inspector of schools, Mathurapur East Circle, Raidegi, South 24 Parganas, for sanctioning family pension along with a family pension. Pension payment order was issued on 12th September 2002 by the Director of Pension Provident Fund and Group Insurance by releasing only the gratuity amount of rupees 10,775.
75.
However, no family pension was granted in favor of the mother of the petitioner. The mother of the petitioner died on 3rd December 2005, leaving behind two sons and two daughters, including the petitioner. the two sons. The brother have died. Both the brothers have died.
Yes.
Hmm.
Past question.
The two sons have already died. The elder daughter is presently married and alive. The petitioner is an unmarried daughter and was dependent on the income of the deceased father. On 17 December 2024, the petitioner made an application with a prayer for sanction of family pension in view of government circular dated, this will be 13th April 2010. The prayer of the petitioner for sanction of family pension was rejected by, which is the order?
That is page 41, 17 January 2025. Page 41. Next
Was rejected by the District Inspector of Schools, Primary Education, South 24 Parganas, VD order dated 17 January 2025. Being aggrieved and dissatisfied with the impugned order, the petitioner has preferred the present writ petition. Mr. So and so, learned advocate for the petitioner, submits that the impugned order record that since the father of the petitioner was not entitled to get pension or family pension, there is no provision to exercise option by the successor of the deceased teacher. In Pramila Behera, sir, in Pramila Behera, in paragraph 12, it says that there was no scope to switch over as he was dead on the date of judgment. This refers to which judgment?
Mukti Power.
Muktimoi.
Para 11.
Para 11.
Did the husband of the deceased employee has exercised option under ROPA 1990?
No, my lord.
No, because CPF under the CPF. He
Then-
didn't take.
Then how he will exercise his option? The daughter will exercise option?
But there is no scope for it because para 12 has already been stated.
Switch over.
Which over.
No. What I am asking is, if ROPA 1990 or 1998, this option has been exercised, it says that there is no question of exercising any further option. Correct. In the present case, that's why the judgment says that since that at point of time, the judgment was not delivered, but the option was exercised, so further fresh option is not required. So they were allowed to deposit the entire share.
No, my submission is this. Petitioner's malad is malad. Superannuation is to be under 60 years of age. Now in the primary school, it has within time, given point of time, there is an extension period of 1 year to 1 year. Now the second term of the extension period, after that he died. Because 18 November 1989 is the last access, last breathing time, and 31st May 1991 he died. So ultimately, the teachers has obtained that options up to the CPF. That's why the CPF options has no scope by the widow or any other persons, seven except the deceased. Because Rupa 1998 to 1999, in view of thereof, as already observed by the special bench judgment, that was not scope to switch over options of the teacher's concern, as he was died on the date of death.
Judgment date. Oh, there.
Para 12 last.
But the para 12 also says that the husband of the petitioner exercised the option under 1990 and 1990. In the present case,
The case judgment has already been given that option, but so far this the instant case, there is no scope to switch over option of the teacher's concept as he has died prior to that. In 90 and 1998, both are the choice of given option. So for the extension period of time, he has been getting the less amount of salary, and he has to be retired up to 65 years of age. But unfortunately, second term of the teachers, he died. This judgment is.
But how this judgment does not help you? In that judgment, Pramila Behra, there was an option exercised. If the option is not exercised, then how the daughter, unmarried daughter, after so many years will exercise?
Para 12, the last question. It has been cited.
We get a clarification from Mr. Sannal.
Pramila Behra is also instant.
Mr. Sannal, you just throw some light because you argued in Pramila Behra. Here is a case where a deceased employee died in the year 1991, 31st May 1991. The widow of the deceased, she approached for conversion. For any reason that was not converted, the PPO was issued, granting her the provident fund and the gratuity, whatever was lying. Now, after her death, the unmarried daughter has made an application for switching over to family pension. But the option was never exercised by the deceased employee. The argument which has been placed into service is that since the judgment of Pramila Behra was not at that point of time delivered, or subsequent earlier decisions in Abhijit Vaidya was not delivered, so the petitioner, the employee was not in a position to exercise. Now the question arises, in all these cases what I see is, some of the petitioners have exercised 1990 or 1998. To that extent, it is very much res integra right now that if the option in 1990 and 1998 is exercised, phrase option by the successor is not required. They will switch over. But here is a case where the option has not been exercised. Now the question arises whether the unmarried daughter can switch over right now.
But will also give me a day's time. But I
Certainly,
cannot
certainly.
recollect of entire thing.
Okay.
I get them a loss of the ratio. I can just the division bench judgment.
Can you take up tomorrow?
Day after tomorrow, your losses keep it.
Day after tomorrow. And I'll next week these in the Monday. Take to clarify Kurani. 13th, Mr. Sannal on 13th early, next week.
Next
on 13th.
copy now.
Would like to get in factor on the joint prayer of the parties for further clarification. Please this matter on 13th. Sir, come on 13th. We'll decide this issue.
13th.
13th.
এটাই বলছি এক্সারসাইজ করতে একটা মামলা প্রজেক্টটা ভিউজ ঠিক সেম ভিউজ হবে এটা বললো এখন এই কি করে এক্সারসাইজ মানে করবে
Yes, Mr. Ghosh.
এক্সারসাইজ
But I was appointed as a teacher in a primary school in the year 2003. In the same school, I was appointed as a head teacher in the year 2012. 2013, some complaint allegedly was made by some of the teaching and non-teaching staff regarding mismanagement in the school. A preliminary inquiry was held, then a disciplinary proceeding was initiated. 12 heads of charges were floated in. 12 heads. Now, I replied to that, the so-called notices. Then, the disciplinary proceeding, after following the procedure according to them, found me, held me guilty. And, ultimately imposed the punishment of dismissal from service with stigma that, no future. I preferred an appeal. Appeal, under the rule 9.
Rule 9 of?
I'm sorry, section 91 of the West Bengal Primary Education. That appeal was taken up, and the order was passed by the appeal committee. If you kindly directly come to the order of the appeal committee at page 173. I am taking 12 heads of charges. It has been taken into consideration separately by the appeal committee.
Kawas in the
যখন হয়েছে তখন বললো মানে
page 173.
172, Lordship kindly comes. Then 173, the relevant portion. It's a long judgment. I'll not put your Lordship to botheration for that.
172.
Because today, I am arguing before your Lordship. Otherwise, the issues involved are to be dealt with in affidavit. I must be candid. For the purpose of interim order, today, I am placing my case on the limited point. Page 172, paragraph 21. only 2 pages I'll be relying on. 172, it is settled principle of law that an order imposing penalty by a quasi-judicial authority must be supported by reasons in support of his conclusions. A speaking order will act its best, be reasonable, and it must be at least a probable one. In the instant case, the finding of the inquiry officer were merely cryptic in nature and no reason were assigned for reaching the finding, and the report was prepared in contravention of Rule 9, 3C and D of the said conduct rules, and disciplinary authority also, while accepting the report of the inquiry authority, which itself was defective, made an attempt to cover the lacuna left by the inquiry authority in his report. And on some charges, the disciplinary authority went beyond the findings given by the inquiry authority. There. For the reasons mentioned in the foregoing paragraphs, the report of the inquiry authority being vague and not based on any reason, the action taken by the disciplinary authority on the basis of such report, dismissing the delinquent from service with the order dated 12th April 2018 is bad in law. So inquiry authority goes entirety. Then, therefore, after considering the facts of the circumstances of this case, on the basis of materials placed before us, we are of the opinion that the order of dismissal passed by the chairman of the respondent council against the appellant dated such and such is liable to be set aside. In the light of the observation made in the preceding paragraphs, and it would be appropriate for issuing directions to conduct a fresh inquiry on the chart being number 1, 2, 4, 7, 10 and 11, strictly in the light of observations made in subparagraph II 4, 7 of paragraph 11 under the heading decision with reason against the appellant for logical conclusion of our prayer. Now, my lord,
Yes.
during the little, my lord, recap of the, my lord, what happened, my lord, before that. My lord, when the disciplinary proceeding was initiated, show cause notice was initially challenged by the petitioner, but that was before this honorable court by way of a writ petition. That writ petition was dismissed, holding that that was premature. Then, my lord, because of during the pendency of the disciplinary proceeding, no subsistence allowance was being given, which I was entitled to get under the law. My lord, I had to again move before this honorable court. This honorable court was pleased to give an order directing payment of, my lord, subsistence allowance. That was paid initially, then again, my lord, it was stopped. I had to move a contempt application. Only on contempt application, it was found that, my lord, there were noting, my lord, by the legal assistant, not even by the chairman, district primary school council, all which, my lord, again, my lord, my subsistence allowance was stopped. It is only on the moving of contempt application, it again started paying. Then, my lord, with the order of, my lord, dismissal, my lord, that completely stopped. Now, my lord, this is the situation by which, my lord, the appeal committee set aside the order directing, my lord, 6 charges to be reheard. My lord, it was remanded. My lord, my scope of coming before your lordship is limited to the extent of challenging that order of remand. That, my lord, under the rules, it says that, my lord, either I have to be reinstated or, my lord, the order has to be upheld. My lord, under the law, because it is to be done in the manner as it has been provided, that is established by this time. Now, my lord, only these 2 modes has been given. Either, my lord, I am out of service. Now, my lord, whether it is with stigma or not, my lord, that's a different issue. Or, my lord, I have to be reinstated. Here it appears, my lord, both the orders passed by the finding of the inquiry officer and, my lord, the disciplinary authority was set aside. Then, my lord, these 3, that too, within the limited scope, my lord, was remanded. Now, my lord, even then, my lord, ordered portion that the instant appeal being 13/2018 is allowed on contest, the order of dismissal of the appellant from the service with a clause of disqualification for future employment as a teacher passed by the chairman DPS Howrah stands set aside with a direction to cause a fresh departmental inquiry with respect to the charge number such and such of the charge sheet dated in the light of the above observation against the appellant, after giving her sufficient and reasonable opportunity of being heard and to conclude such inquiry within 3 months from the date of communication, my lord, kindly mark this, within 3 months from the date of communication of this judgment and order treating the appellant as if she is under suspension for an uninterrupted period since the date of her suspension. So, my lord, it is to be done within 3 months. Time period is fixed. Treating that, my lord, I am not out of service. My service is not dismissed. My lord, I am under suspension. This is the status. My lord, that was decided by the appeal committee. The chairman DPSC Howrah shall be at liberty to appoint a fresh inquiry authority if the earlier inquiry authority is not available in his disposal. The rest charges be treated as dropped.
Yes.
However, the chairman DPSC has liberty to consider any application by the in accordance with the rules if made for withdrawal of or suspension during the pendency of the inquiry. So, my lord, my status pursuant to this order, my lord, under suspension, and I am facing 6 charges within the limited scope, which is to be concluded within 3 months. What did, my lord, the District Private School Council do? My lord, they preferred a writ petition before this honorable court, seeking stay of this order. Now, my lord, this honorable court was pleased to pass an order of maintaining status quo and exchange of affidavits. My lord, that writ petition, exchange of affidavits is done. And my lord, the order, my lord, that order, my lord, I have annexed at page 178. If your lord, page 170. Cannot be decided without exchange of affidavits. Affidavits have been exchanged, but that is ready for hearing. Therefore, the respondents are directed to file affidavits. These have been done. Then, in the meantime, the parties are directed to maintain status quo. That means, if this status quo, as of today, my status has been decided as in the appeal committee's order. It is to be, considered that, I am within the service, I am in the service, but, there is an order of suspension. At worst, I say the moment it is 3 months over, the moment it is 3 months over, if it has not been done, the rule says that, they are under obligation to comply with this because the order of the appellate committee is a final authority. Now, if that order has to be complied by the disciplinary authority as has been given, if there is no order to the contrary, there is no order to the contrary. So, I say, I have to be considered to be, within the service. I am entitled to join my post, which I went there. I was not allowed. I again applied to the appeal committee, but appeal committee was not working. Appeal committee started working only in the year 2024. That was conveyed to me because of pendency of their writ petition. Appeal committee is restrained from taking any further step. So, they are using this pending writ petition, as a alibi for the purpose of defying my rights. Now, if your lordship kindly sees,
Affidavits have been filed in the earlier writ petition.
petition, that would be one of my prayers, that both the writ petitions can be treated to be affidavit against each other, and both these can be heard together so far the final disposal is concerned. Today, my prayer, the worst possibility that I am entitled to. I am saying that I am entitled to join the school, and I am saying that the suspension allowance. Since the date of the order passed by the appeal committee and considering the order passed by this honorable court in their writ petition, is to be paid to me. Now, if your lordship kindly allows me, this is rule 11 of West Bengal primary education. I am handing over to your lordship, the book Conduct of Service of Teachers Primary School.
It is there.
2001. Yes, well, I'm giving that to you. My lord, kindly seize, from my book. May I read it and hand it over? That will be easier for me. Now, Conduct of Service Rules, Rule 11. It says, may I read it? A teacher may prefer an appeal against an order imposing penalties mentioned in Rule 8 to the appeal committee
constituted under section 91 of the Act, and the decision of the appeal committee shall be final. Then Rule 12, implementation of orders of appeal committee. The authority which passed the order appealed against shall give effect to the order passed by the appeal committee, and in doing so, it shall furnish to the teacher concerned a copy of the order passed by the appeal committee. This is already with me, but shall give effect to the order of the appeal committee. Suspension. This is, and within 3 months. Now, if your lordship kindly allow me, my lord, that is with regard to, my lord, the merit. My lord, Rule 9, my lord, decision of the appeal committee. Rule 9, my lord, under which, my lord, they have. My lord, Rule 9, my lord, really on merit that, my lord, there is no scope of remand. That is, my lord, so far, my lord, my writ petition, the limited challenge, because otherwise the order of the appeal committee is in my favor. And, my lord, Rule 7.4a, that my entitlement to get a suspension allowed. Rule 7.4a. My lord, it says, a teacher under suspension or deemed to have been suspended shall be entitled to the following payments. During the first 3 months of suspension, a monthly subsistence allowance equal to the amount of pay which he would have drawn if he had been on half-pay leave. Provided that where the period of suspension exceeds 3 months, that's why, my lord, 3 months was mentioned by the appeal committee, exceeds 3 months, the appointing authority shall be competent to increase the amount of subsistence allowance for the remaining period of suspension by such amount, not exceeding 50% of the subsistence allowance admissible during the first 3 months of the suspension, if in the opinion of the appointing authority, the period of suspension has been prolonged for reasons to be recorded in writing. Then, my lord, the other things have been given. Now, my lord, so 3 months, and my lord, thereafter 50%. Now, if your lord, you kindly see the we take.
Yes.
But I have given your lordship, my lord, 7.4a. Please to get 7.4a. That is with regard to my entitlement.
Which even have drawn. So after the order of the appeal committee, you have been granted subsistence allowance.
See, only that writ petition and that order of status quo. And below, it was in the year, below the order of the appeal committee, below, I intended to join the school. That's why, below, second time I approached the appeal committee. Below, unfortunately, appeal committee was not working. Below, the order of the appeal committee is of
4th January 2019.
4th January 2019. Since then.
Okay.
So, by the month of March, 3 months period was over. Their writ petitions order is dated below 19th June 2019.
What is the prayer in the earlier in the writ petition filed by the board?
They say below that order of the appeal committee to be set aside and my order of dismissal to be out.
Okay.
Appeal committee below acted with material irregularity.
Is that all?
That is. Interim order below I have prayed for, if your lordship kindly sees. Because below the rest is to be dealt with in my respectful submission to expedite. Below lordship kindly consider the plight of a employee below since below 2012 below it is continuing. Below my prayer is prayer E at page 37.
Okay. Mr. Sarnal, after the recess,
Yes.
you make your submission.
Only one thing I have a fixed matter before the Honorable Division Bench right at 2. May I come back at 3 or like that, Your Lordships?
Yes.
Just
So go.
Just after he's finishing that, I will come up.